Today we are going to discuss about the various aspects of memorandum of charges under rule number 14. As I have explained in one of my earlier videos, once the show cause notice is issued against an individual and the reply is received on the show cause notice from the accused person, then the action to be taken by the disciplinary authority may be he can close the case, or he can go for administrative action, or he can decide whether he has to proceed with the disciplinary proceedings either under major penalty or under a minor penalty. If it is a minor misconduct, he may decide that only minor penalty is to be proceeded with, so the proceedings are different. In case the disciplinary authority decides that this case is a gross misconduct, major misconduct, may be requiring a major penalty, then the proceedings has to start under the disciplinary proceedings for a major penalty. The first step in proceeding with this is to prepare a charge memorandum and issue to the persons who are involved. Once the charge memorandum is issued, you have to allow at least 10 days to reply, or it can be further extended if on the request if there are valid reasons. You should allow the inspection of the documents by the charge employee. On getting the reply, either close the case or issue an order for an inquiry under rule number 14. So, this is the proceeding once if you are to proceed with a major penalty. Here we are discussing about the aspects of memorandum of charges, or generally called as a charge sheet. A charge sheet is a first step once the disciplinary authority decides that we have to proceed against the individual for giving either a major or minor penalty, or most probably a major penalty. Then the first step is to issue a detailed charge memorandum. This is a very important document to be prepared, very accurately prepared. What is written there, what is not written there will decide the fate of the case. So, this document is to be prepared with due care and attention. A charge sheet is to be issued within 2 months on receipt of the investigation report, or in cases where the case is referred to CVC, Central Vigilance Commission, within 1 month after getting their advice, the charge memorandum shall be issued. But remember, there is no time limit between occurrence of the case and the issue of charge memorandum. You can issue a charge memorandum on individual for an incident occurred 10 years back also, 15 years back also, 5 years back also. There is no time limit for that. But once you conducted an investigation, preliminary investigation, and the report is received, within 2 months the charge memorandum is to be issued. The memorandum of charges basically consists of the main memorandum of charges attached with 4 annexures. The main memorandum of charges consists of a standard page only, and then annexure 1, which is called article of charges, annexure 2, the statement of imputation, annexure 3, the list of documentary evidences, annexure 4, the list of witnesses. The main page of the charge sheet is a legally worded page, basically containing the name of the individual and giving him and specifying what are all the rules and other things under which this is issued, nothing else. It is only a legal document. Other than the name, everything else remains common in any memorandum of charges. The real details start from the article of charges. The article of charges, which is annexure 1 to the charge sheet, contains various articles, article 1, 2, 3, depending upon how many charges you are putting under this memorandum of charges. Each article should be very specific and quote the rules. You should, in each article of charges, you should write what is the violation, you should bring it to the notice that you have done a particular misconduct, a brief of the misconduct what is done, and you should quote the rules, what are all the rules you have violated, that is what are all the rules of the CCS conduct rules you have violated, and hence this you are charged with these violations. Please remember that when you are issuing the charge sheet, you should not or need not give the reference of the investigation you have done. The preliminary investigation shall not be referred in the charge sheet. You should not say that we have conducted an inquiry and the inquiry report is like this, so we are issuing the charge sheet. You should only say that it has come to the notice that you have conducted this, this is a misconduct which amounts to violation of the following rules, hence this charge, article number 1. And also remember that the preliminary investigation report shall not be given as a document or an evidence. Whatever documents given by the preliminary investigation report, the original documents, became the list of documents or list of evidences to be put in the charge sheet. So, article should simply say what is the violation, what is the act which we consider as a violation, and what is the rules violated. Each act of misconduct has to be in a separate article. Unless it is related, if the 3 or 4 misconduct, it should be given as article number 1, 2, 3, 4. Because when you are conducting the inquiry officer will be addressing each charge separately. He may find that charge number 1 and 2 are proved, 3 is not proved, or 1 and 3 are proved, 2 is not proved. So, each misconduct should be in a separate article. And in the article of charges, you have to only mention what is a misconduct and what is a rule violated. Details will not come in that. Second annexure is statement of imputation. Generally, I have found that people do not know the difference between article of charges and statement of imputation, and whatever is written in article of charges are repeated in the statement of imputation. These two are two different annexure. In statement of imputation, for each article of charges, if there are 1, 2, 3, 4 articles, there should be 4 statement of imputations for each article separately. It explains how the misconduct was done and detected. That should be explained, and how we have concluded that this misconduct is done. How we have concluded? It is from the evidences, the documentary evidence, and from the statement of the witnesses. So, for each article, when you have written that you have this misconduct has come to the notice, this is a misconduct, we have arrived at that you have conducted this, you have done this misconduct from the evidence number 1, 2 and 3, and how that evidence number 1, 2 and 3 are related to this misconduct shown in article 1 should be explained in the statement of imputation. So, if there are 10 evidences, 10 documentary evidences given in the list of evidences, for article number 1, which are all the documents you have seen, that connection should be clearly written in the statement of imputation. That is the purpose of statement of imputation. Or if you have given the statement of witnesses as an evidence, how that statement proves that you have conducted this misconduct. That should come in the statement of imputation. Preferably, in the list of documents, you should not give any document which is not mentioned in the statement of imputation, or similarly all the documents mentioned in the statement of imputation should form a part of the list of document. These are interrelated. If you mention anywhere any document, you mention in the statement of imputation that you have found out this misconduct from a particular evidence, particular documentary evidence, that documentary evidence should be numbered and put in the list of, that is annexure 3, the list of documents. So, statement of imputation connects the list of documents and list of witnesses. Remember that once a charge sheet is issued and the list of evidences are given and list of witnesses are given, further it is not possible to add any additional evidences or documents after the issue of charge sheet. You can amend the charge sheet, that we will discuss separately to some extent, but additional evidences, adding additional evidences, bringing additional witnesses would be difficult. at the time of inquiry. So, the article annexure 3, the list of documents is to be prepared very judiciously after due thought process in adding each document. One more major violation I have seen in issuing the charge sheet is, in many times we issue the charge sheet without having the physical custody of the document. Ensure that once you are issuing the charge sheet to an individual, all the documents in original should be available with you. All the documents mentioned in the list of documents annexure 3 shall be available with the department, or at least department should know where it is available, because once you issue the charge sheet, the accused person or the charge officer, CO, the charge officer has got a right to verify the original document, no, not a copy, not a certified copy. If you cannot show the original document of a document given the list of documents, that document can be and will be discarded at the time of inquiry. The charge official has got every right to request for, and it has to be complied, that particular document for which original cannot be produced by the department or the disciplinary authority, that document cannot be taken in the inquiry as an evidence. That evidence is nullified. So, before issuing the charge sheet, ensure that all the documents you have mentioned in original is available with you or can be produced for the verification of the charge official. It is his right that he has got a right to verify these documents. I have seen lot of violations in this. This is a very important aspect to be looked into, and lot of cases have gone out of control because documents could not be produced. And the people who are issuing the charge sheet thinks that the copies will be produced, copies are equally good. No, because in a few cases it is proved that there is a difference between what is written in the copy and what is in the original. And then comes a list of witnesses. You can include all the witnesses who have given a statement, whom you would like to call at the time of inquiry in support of the charges can be put in the list of witnesses. That should be including their name, address, designation and other contact details should be there. Now we will go to the important points in the charge sheet. Remember that the charge sheet is prepared based on the preliminary report. As I have already told you, the detailed preliminary report with the facts and figures forms the basis of the charge sheet. It is the duty of the preliminary investigation officer to make this available, or the disciplinary authority to ensure that these are available before issuing the charge sheet. I found that at least 75% of the charge sheet issued violates this basic requirement. Either the documents are not available, or you refer 10 documents in the list of documents and in the imputation only 3 are referred. So, why other 7 are there? We do not know. Or lot of documents are mentioned in the list of imputation and only 3 are mentioned in the list of documents. And when the inquiry starts, the department comes out with so many additional documents. The charge officer says, these are not in the list of documents, not in my charge sheet, it goes out. Only option is you have to issue a fresh charge sheet, start a fresh inquiry. It is not very easy. The language is very important. The language in the charge sheet at any point of time should not show a prejudice, should not show that you already decided on the case. Till such time the final decision is taken, that individual against whom you are proceeding is only a charge official, he is not a convicted official, he is only a charge official. The charge official has got every right is to prove his innocence, that is there in the rules, that is there in the constitution. So, you should give an opportunity to the individual at every point in the proceeding to represent himself, to prove his innocence. Once a charge sheet is issued, it can be amended during the inquiry to some extent, but cannot add more facts or new charges. If there are any factual errors within the charges issued, that can be amended during the inquiry. It is pointed out that this is not correct, then that can be amended, but you cannot add more facts in support of your case. You cannot add a new evidence in support of the case, or you cannot add a new charge. You say now article 1 and 2, and now we are adding another charge 3. It will become a separate case, it cannot be the same case. And when you are issuing the charge sheet, the charges preferably shall be listed in the order of seriousness. Article number 1 is serious most, and article number last article is the least serious. Even though it is not very mandatory, because sometimes you cannot decide which is a more serious misconduct or which is not less serious, then it can be just numbered and given. And date of issue of charge sheet is another important aspect. A charge sheet is deemed to be issued not on the date of signature of the charge sheet. It is deemed to be issued once it is dispatched. The proof of postal dispatch, that will be the date from which charge sheet is issued, not from the date when charge sheet is signed. You can sign on any date, but only on the date it is dispatched. The proof of dispatch, that date is the date of issue or date from which charge sheet comes into effect. The date is very important because from the day a charge sheet is issued under a major penalty, that particular charge official comes under the ambit of a disciplinary proceeding. Lot of things for him stops on that day. No charge sheet should be issued as a routine, because remember that once a charge sheet is issued and enquiry is to be conducted, any enquiry is costly to the government and costly to the individual as well. And one more thing regarding the date is, the IO and PO shall be appointed only after the charge official denies the charge or do not respond on the date specified. Once the charge sheet is issued, not even on a noting sheet, you approve the name of the IO or PO before the charge official gives a reply, or wait till such time you are given the last date given in the charge sheet. Once the charge sheet is issued, if the individual does not reply, you are not supposed to order the inquiry immediately. He has to be given a reminder. The rule says the individual shall be given at least one reminder that your charge sheet has not been replied. I am proceeding with the inquiry. So that is also a right to give enough opportunity for the individual to reply. And only after that date or only after getting the replies where the charge official has denied the charges, then only you do any action in appointing the IO or PO. These are the important aspects which I would like to mention as far as the charge sheet is concerned. Remember that disciplinary proceedings, once it starts with the charge sheet, is a very important aspect to be done judiciously after due application of mind. It is a serious affair both for the department as well as for the individual. And remember that once the charge sheet is issued, there has to be an inquiry and department has to defend their case in the inquiry. So there should be enough material available and we should give enough chance for the charge official to defend himself. Both are important. That's all for the time being. Thank you very much.